socket and an elliptical magnet that rotates, or a cylindrical magnet that rotates, but I could do an axis, I could do round magnets, I could do non-conforming edges, I could do a lot of things that he didn't require. I can do a variation that's not the way he claimed it. Okay, what else can you do? We looked at the box, and where was it patented?
China and US.
US and China. What can you do?
Somewhere else.
Foreign markets, right? Give up. The little felty end was all stuck in it. Go to foreign markets. We can wait for it to expire. We can see if they're current on their fees, because a patent can last 20 years, but if you don't renew every 5 years your fees, what happens? It expires 5 years or 10 years or whenever you didn't renew. So it might expire sooner if they haven't paid the fees. So we can look at, the year of expiration, whether the fees are current. What else can we do? He patented it last year in every country you can think of. He's current on his fees, and the claims are airtight. He's what can you do? License. Right? License is just permission for a fee. So you say, hey, I'd really like to, I see you've got this magnet patent. So you got this magnet patent, and I really like the idea. In fact, I thought of the idea too, but then I saw you had it, and I've got a lot of ideas how to market it. And what do you say? I get it out there, and I pay you something for the right to do that, for permission. Or you might just say, you know what? I see you have a patent. You've invested some money, probably about $10,000. I've got $10,000. How about if I just buy that patent right off again? How about if I just buy it? And sometimes people are willing to sell it. They invested in it. They got disenamored with the idea for some reason and moved on. But they put all that money into it, and they're like, yeah, you can buy it. Okay? So here's a lot of options if you find out you're blocked. Then we talked about the possibility of improvements. Right? Got the television set here. I'm the worst on the board. Television set, but somebody's already got that. Or maybe it's already in the public domain and several companies are selling it, but you can think of some improvements. Color, cable, flat screen, remote, HD, right? Give me some others.
4K.
What?
4K.
4K?
4K. The new HD is like the new thing.
Okay. I can't even keep up. My brain's too old to keep up with how fast technology is. What else? 4K, 8K, 10K, 3D, right? All kinds of things. And so we call this fencing in. Fencing in the patent by coming up with improvements that prevent the original inventor from getting that improvement, because you got to the improvement first. So then you can license the improvement to that party and get money for that. Right? When you're licensing, now we're talking about television, tons of television companies. You come up with a new invention for television. It's really awesome. I don't know what it is. 4K or something like that. And you can either go to one company and say, hey, I have this new invention. It's going to revolutionize television, and I will give you the exclusive rights so that you can exclude all of your competitors. You're the only one that has 4K television. You could do that. And that party would probably pay a premium for that, right? Because they get to now own the market for 4K. Or your strategy might be, what if I got a little bit from every single TV that gets sold from here on out? So you do a non-exclusive license, and you just get a smaller royalty, but from everybody. So there's kind of two ways to think about licensing, doing an exclusive or doing a non-exclusive. Does that make sense? Okay, and then the last strategy was the stack versus stack. And that's where you know, this company's got a big stack of patents, and they say, you know what? Company A's got all these patents, says to Company B, we're gonna sue you for patent infringement. You're violating one of our patents. And Company B says, oh yeah? Well, look at my stack. You wanna sue me? That's fine. I'll put some law clerks on the project. We'll look at all your technology, all of our patents, and you can bet your bottom dollar that you're gonna get sued back. Because if we're infringing something you're doing, you're infringing something we've got. And so technology is kind of Cold War, mutually assured destruction, right? You file, you launch that first missile of a lawsuit at us, we'll wipe you out. We'll go to our stack and we'll find a way to wipe you out. And so companies are less about what's the details in the patent, honestly, because technology is moving so fast that by the time you get a patent, you know, technology has moved on. But owning these huge stacks of patents says, don't come after me, because I've got a missile silo here, right? I've got bunkers. I will bring you down if you come after me. Okay, so those are the patent strategies. I want you to be aware that patent strategy exists, and not to be scared off by, gosh, it looks like somebody's already claimed this space. If you've got an idea, go talk to an attorney and say, looks like somebody's already claimed this space, here's a copy of their patent, what can we do? Is there anything we can do? And there are things that exist to help you get past that. Okay? So I think we got that far in the 9:30 class, but I know some of the 8 o'clock kids didn't see it, so that should get everybody caught up. Okay, in terms of exam review. Exam review. The exam it will be open when you get out of here if you want to go. We have no class on Thursday. So if your life is so busy you can't get to the testing center any other time besides this window of time, it's open. It'll take you about an hour. It's 46 questions. It's somewhere between 50 and 60 points. I don't know. So there's some questions with multiple points. Yep, more review sheets.
Got one. Thank you.
Got one. Okay.
So 46 questions?
46 questions. You should be able to complete it in an hour. If you really, like to spend a lot of time with your exams, you might want an hour and a half. But you should be able to complete it in an hour. The exam closes Friday. We're too big of a group to get a Saturday close date at the testing center. They restrict big classes from closing on Saturday. But I don't know what time it closes on Friday night, so make sure you know that if you're going to go to the wire. Yes?
Did you say it was multiple choice?
It is, it has some multiple choice. It has a lot of short answer, some explain to me how, this or that. So it's kind of a mixed exam. There's one section on the exam that I want to make you aware of. And I'll explain why I do it the way I do it. It's sort of a multiple right answer, multiple choice. Don't get freaked out. Let me show you what happens. Let's say it's which type of IP can last forever. There's about 10 questions that are like this, and they're all in a group, and it's clearly marked. You're in the multiple right answer section. So every single answer choice is the same. Trademarks, copyrights, patents, trade secrets. So, which type of IP can last forever? Can trademarks last forever? Are you sure? Let's think about a company like Coca-Cola. Do you think that's going to last forever? Yeah. So, okay, that's the right answer. Copyrights, how long do copyrights last? We don't know, but we're going to ballpark it at 100 years because it's gotten so complicated that it takes an expert to figure it out. But we know it expires somewhere around 100 years. What about patents? 20 years. What about trade secrets? Can they last forever? Oh, if you're really good, they can last forever. So that's what you're going to pick. If you go through and you just circle them all to game it, you'll miss 2. Okay? So there are multiple points, more points available in this section. Most of the questions, if it's a 2-point question, I tell you it's a 2-point question, but in this section I don't, so you can't do the math backwards and figure out what you're missing. But let me tell you why I do it this way, because I know that looks confusing. But you're going to watch for this section. Here's the alternative. I don't want to do E is A and B, but not C, and F is 3, but not 4. I don't want to give you all these variations on stuff at the bottom. That just gets more confusing, right? Isn't this more straightforward to just say, oh, I know it's always going to be the same 4 choices, and I know what I know, so I'm going to pick the ones that feel like they fit, right? And ignore the others. So that's what that is. I think it's more straightforward for you than me trying to give you an all of the above, none of the above, all but C, none but D, or whatever. Okay? Yes?
So you're going to tell us when we are to take more than one right answer? And is it always
It's in 2 places. It's on the exam instruction sheet. It's going to say, pay special attention to the instructions for, I think it's questions like 24 through 32 or something like that. Then on the exam, it'll say for the next multiple choice questions, you can pick more than one right answer, as many right answers as apply. And you'll see, and then after that section, then there's some short answer and some other stuff, and then the rest of the test, don't worry about it. It's just that one section, okay?
But there's always more than one. So you're
Oh, there might be just one. It could just be one. There's never, none of them are right. There's always at least one right answer. There could be all 4, there could be 3 or 2, okay? So don't let it trip you up. When you're sitting there and you're cursing my name, just be glad that I'm not giving you an E and an F and a G and an H and an I possibility. I'm just letting you pick the ones you think are right, okay?
Is there ever one with all 4 right?
I don't think there's ever one with all 4 right, so don't be tempted to circle them all. I probably just gave you a point missing. You were paying attention. Okay, other than that, the exam is pretty straightforward. I'm going to have you explain some things. There's going to be a few fill in the blanks, but you'll do great. You'll do great. I think we've covered this and covered it and covered it. Okay, so last, clear back to the past. First lecture of the semester, first couple of lectures. We drew out the branches of government. We talked about where laws come from and how are they enforced. Where do laws come from? The legislature, but who enforces them? The executive, and they're enforced through something called regulations, right? And regulations are where the laws get detailed, and sometimes they overlap, and sometimes they're inconsistent, and that impacts who? The worst.
Small business.
It impacts small business the worst because they have percentage-wise, fewer resources to deal with them. If you're BYU, you've got 30,000 employees or whatever BYU has. You can throw a couple guys on being completely focused on whether or not we're following regulations. But if you're a small business and someday you're the buyer and someday you're the cashier and someday you're the shipper and someday you're the stocker and someday you're in charge of regulations, you're spread too thin to be able to manage your whole business and keep abreast of regulations. So what is a good process for small businesses? What's the key? How do you keep abreast of the regulations that are affecting your business?
Join
the,
I can't remember the bigger groups.
Join an industry group.
An industry group.
An industry group. Join an industry group. That will serve 2 purposes for you. One, it allows you to affect the political process because you can put your input into the industry group and then the industry group, interacts with the government. And 2, when regulations come out that impact the industry group will inform the participants in that group of what's affected the industry. So there's strength in numbers there, right? So can you articulate what is the connection between a liberal administration and how small businesses are impacted and impact the economy? Like, chart that out for me. What's with the liberal administration? Why do I bring that up? Sounds political. This is a business class.
We usually make more regulations.
Liberal administration, based on their philosophy, more protective philosophy, tend to have more regulations. They're more focused on consumer protection than business freedom. Whereas conservative administrations are like, take the restraints off of business. When business is going well, people in general benefit. The rising tide floats all the boats, or whatever that saying is. So, but liberal administrations are heavier-handed with regulation. Why? Are they just mean? Why are they heavier-handed with regulation? What's their objective? Protect consumer and protect who else? Who are regulations designed to protect? Environment, customers,
Other businesses.
other businesses. What's that? Competitors, animals, children, minorities, elderly. Anyone who is unsophisticated or has no political voice. Right? That's who regulations are designed to protect. So you may be very sophisticated. You're a business student here at the Marriott School at Brigham Young University, pretty prestigious, hard to get in. You're smart, you're bright, you're probably getting good grades. But when it comes to certain things, you're still unsophisticated. None of you have purchased a home yet, or so a few of you have, but not very many. That process is overwhelming. If you haven't been through it before, you are unsophisticated in that process. And so the government is going to want to make that process more transparent and more user-friendly so that you're not bamboozled in some way by a process, or by a realtor or by a mortgage broker who's telling you something that's not right. Okay, so regulations are always designed to protect those without a political voice, environment, animals, those who are unsophisticated, less educated, more vulnerable, more in need of protection. Okay, how are regulations promulgated? How are regulations promulgated? That's a big word that means made.
I was going to ask what promulgation was.
Created. It's for some reason that's the word that goes with regulation and nothing else, right? Remember that we talked a little bit about this should be a democratic process, but it's not quite, but it is a little bit. Do you remember?
Once laws are passed in the Senate or Congress, then they go to the different executive branches that then put it into regulation and they define laws and rules and regulations.
Right, but what is that process? Do you remember it?
Isn't it called a registry?
There was a document called the Federal Register. So the document here is the Federal Register, and the process was called, do you remember it?
I don't remember what it's called, but doesn't it basically have like 60 days to look through it and then file if they have any objections?
Okay, so here's what it's called. It's called Notice and Comment Rulemaking, and he's exactly right. He described it exactly right. So the Federal Register comes out every couple weeks. Every agency can publish their new rules in the Federal Register. And they'll publish what's called a proposed rule, and then they open a comment period for like 60 days. You can, if you don't like the proposed rule, you comment why it's going to impact the industry or hurt consumers or hurt the environment or whatever it is. And then at the end of that comment period, they reevaluate, take into account the comments, and then they'll publish a proposed revised rule, more comments, and then a proposed final rule, and then there may even be comments there, and then the final rule goes into effect. And all of that process is published in the Federal Register, and that ability to comment is called Notice and Comment Rulemaking. And how do you comment as a small business? Who does it for you? Your industry group, right? Okay, and when the new rule comes out, that's going to affect your industry, that same industry group is going to turn around and send the information back the other way to you and say, this is what you have to do, this is when it goes into effect, and this is how we recommend you deal with it. Okay? So industry groups are invaluable for small businesses. Occasionally, yeah, let's just leave that. Okay, so I don't want you to worry about what kind of commercial information is regulated. The answer to that generally is personally identifiable or private information, but I don't want to we didn't spend time on that in class, and I don't want to, it's not on the exam, so I don't want to spend time on it today. Major regulations affecting business, scratch that one out too. We're not gonna worry about that. Some of the ones there change more frequently than I update course materials. So if you're in business, you'll join an industry group in that. Okay, any questions about that process? Would you be able to articulate what is in the economy? What kind of business is the driver of the economy? Big business or small business? Small business is the driver of the economy. They're like 65% or 70% of all net new jobs are created by small business. So I want you to be able to think in your mind and articulate from, having a liberal president in office. How does that impact the economy? Okay, because a liberal president, more regulation, means small business have to put more of their resources and their capital into compliance, means fewer small businesses thrive, means the economic driver isn't as efficient because there's not as many small businesses wanting to get involved in certain industries that are overregulated, means it impacts the economy. Okay? Now, I could put on my other political hat and say, gosh, no regulation, people are hurt, they don't have a way to stop it, businesses take over, capitalists run amok, and we have to have regulation. That hurts the economy. People out of work for whatever reason because there wasn't enough regulation to protect them, that hurts the economy. So you can take whatever political point of view you want, but be able to describe the connection between liberal or conservative administration, how it impacts through business and affects the economy. Got it? Okay. You've got that. You've got the first section down. You shouldn't have any trouble. You've got some vocabulary there we went over. Some ideas on how to code. You're good. I'm tired already, are you guys? It's a lot of information. Okay, legal formation. This is the chart that should help you be prepared. Now, in contrast, it was a much easier chart, wasn't it, than the IP chart. Big takeaways here. The first two, sole proprietorship and partnership, that's when you just jump into business. You don't really file anything. If there's one of you, you're a sole proprietorship. If there's more than one of you, you're a partnership. It's just the default. It's the default category that the law puts you in so they know how to deal with you if you haven't taken some forethought to create a legal plan and become a legal something else. Okay, so it's just the default. The problem with the default, the benefit of the default is there's nothing to file, and so it costs a little bit of money, it doesn't cost any money, and you're just there. The downside is that you have unlimited personal liability. If something happens in your business, you have to take your own personal money to fix it. Someone gets hurt, you get sued, you get in debt, your own personal money is on the line to fix it. But if you file something with the state, corporation, or limited liability company, or a few of other varieties that have come up in class with questions, focus on these main three, then you get liability protection, right? Your personal liability is shielded, and the only resources that someone suing the company can get is the assets within that company. So it's worth it. It's worth doing that. So those are the big takeaways. Let's flip over, and I just want to make sure we know the vocabulary and concepts that come with this chapter. Okay, corporations are formed under state law. So every state has their own statute, their own series of laws that deal with corporations. probably 95% of the state statutes are the same across the board. You pull up two states and randomly compare one of their statutes. very, very similar. Lawmakers don't sit in the back and, write fine print all day, right? They borrow it from somebody, some other state that's already done it, and then they tweak it the way they want it. So state laws are fairly consistent, but also state laws have some unique points that were inserted to attract companies to their state. What are a couple of the states that we talked about that have unique laws?
Nevada.
Nevada, and give me a couple benefits in Nevada. Cheap, anonymity, you can shield who your shareholders are if you don't want people to know. But the big headliner kind of is that you don't pay state income tax. Remember, all of these corporations are separate legal entities, which means they're separate taxpayers, which means they get taxed just like people unless the state gives an incentive. And in Nevada they say, and Wyoming, they say, you know what, come here, you'll still have to pay federal tax, we can't control that, your federal income tax. But you don't have to pay state tax, we're not going to collect it. We have other ways of getting revenue in Nevada, so come here and we won't make you pay state income tax. So there's an incentive. Easy to set up, you don't have to have much of a corporate presence and other things like that. And then there was another state that was well known for a reason, and what was that one? Delaware, and what was the reason? Who files in Delaware? Who files in Delaware?
Everybody.
Not everybody, but all public companies file in Delaware. And the reason is that they have the most long-established state laws. So, if there's been a dispute in a public company, it's come up in Delaware. And you can already look at the case law in the history and kind of figure out what's going to happen. So it's well settled, it's well established. Not a lot of risk in Delaware courts for corporations when they get sued. They know what's going to happen. And there's some other incentives in Delaware that fit well with public companies. And so Delaware. So no Delaware and Nevada, and why they're important. The state law is that state statute is kind of the underlying assumption of what things are going to be. But if you want to write bylaws, you should write bylaws. Your bylaws can just be the same as state laws, or you can be more specific or more detailed with your requirements for your company. So, let me give you an example. State law might say you've got to have one shareholders meeting and one directors meeting a year, as a minimum. And you're like, no, that's okay, but I think for my corporation, I want to have them every month. Now, maybe that's crazy. But you can always do more, be more detailed, but you can't say, you know what, every year, that's a hassle. How about if I do it every 5 years? Why can't you do that? State law sets the minimum of once a year, so that's the standard, and then you can be more detailed in your bylaws. But if there's something that you forget to put in your bylaws that comes up, you can always go back to state law. Or something in your bylaws that seems unfair or wrong, you go to state law. What does state law say? If it's inconsistent, then state law is gonna trump it, right? If it's inconsistent with the state law minimum requirement, state law will trump. As long as it's consistent and you're just giving more detail, that's okay. Okay, in a similar vein, governing partnerships, usually that happens by, in theory, the partners entering a partnership agreement that decides who has what percentage and who can sign on the books and who has signing authority on the checkbook and other things like that. Usually, in theory, partnerships are going to enter those agreements. What do you think happens, though, in practice? They don't enter the agreement, right? They forget, because they're just jumping into business anyway. And so if partnerships either don't enter an agreement with each other about the governance of the partnership, or they enter a very vague agreement, maybe it only has a few details, but it doesn't cover all the possible areas for dispute, what's the gap filler? What do the courts turn to fill in the gaps and figure out disputes? The Uniform Partnership Act. So the Uniform Partnership Act is a state law that's going to help courts solve disputes between partners only when those partners did not enter a partnership agreement. or sufficient parties.
So this is the Utah state law you're talking about?
Yeah, it's
Every
uniform
state
law.
had one?
Yeah, it's a uniform, it's pretty much where there was a uniform law and each state adopted it. Sometimes they'll make a little variation, but usually they just adopt it the way, usually the ABA or somebody that writes the uniform laws and suggests them to the states, and they either take it wholesale or modify it a little bit. So we call it a uniform act because most states have it, exactly.
So is this different than the state, corporate state laws in that if you write it, you can write anything you want and it doesn't trump what was written?
Yeah, that is a distinction. For partnership, you can kind of write anything you want, and the courts will go with that, unless you forget to write something, and then the courts will turn to the UPA if there's a dispute. So here are some of the things that the UPA has. Partners have equal share of profits or losses. So if you're 70-30, and you happen to be the 70, and you don't write it down, what's going to happen? It becomes 50-50. So if you have more than what would be an equal division, you have the incentive to write it down. If you have less, you're like, we'll worry about that later. Then you get in the dispute, right? Okay, partners will not compete with the business of the partnership. Partners have the right to inspect the books of the partnership. Any partner can bind the partnership. If you don't limit in your partnership agreement who has check signing authority, any partner can come in and get a check and spend partnership money. If you don't. So, it's good to know. It's good to know what's here because you probably want something different than what's here.
For partnership agreements, is there certain rules that you have to do or a certain format? Or is it
Not
just
really, no. Some
something
partnership
that's signed?
agreements are oral and the partners just agree, yeah, that one day when we sat down at the restaurant, we both said 50-50 and we're gonna be honest and say that in court, you know, that could happen. Sometimes you write it on the back of a napkin and that's all you have, you know, is proof. Or sometimes it's emails back and forth when you're talking about or text saying this is what we thought we would do. But hopefully, you actually sit down and come up with a document saying what everybody's putting in and who has signing authority and what you're going to do and how you do decision making, things like that. But it's really an open possibility is how you do it. Okay, you know what piercing the corporate veil is? Any questions about that? Okay, do we know what corporate formalities are? They're listed here for C Corp and S Corp. The corporate formalities are listed. There's several of them. Having a board of directors, appointing officers, having annual meetings with minutes of those meetings, signing resolutions, signing renewals. Having separate banking accounts is an important one to put under both C Corp, S Corp, limited liability company. We talked about it in class, but I don't see it here. So making sure that you're not commingling funds, that you keep separate banking accounts. Separate physical locations are very helpful if you're fighting a piercing of the corporate veil. What happens when the corporate veil is pierced? Yeah, you become personally liable. It's like you never set up the entity in the first place. You're back in either a sole proprietor or a partnership legal jeopardy, legal risk.
When you say like it's pierced,
So what would happen is, let's say somebody sues me, and I say, oh, you know, you can't collect because I've incorporated my business. So go talk to the corporation, and the corporation says, we got no assets. And here I'm sitting on all these assets, and the person is out. Maybe they've been injured and they have hospital bills, and they try and sue the company, and I've got all the money and there's no money in the company. And so they go to the court and they say, you know what? There's this sort of social contract, right? We only give this opportunity out to people who follow the rules, follow the corporate formalities. And I don't think that person, I don't think she has followed the formalities. Court, will you take a look and determine whether or not she's followed those rules that provide that liability? And the court will ask me for my corporate records, my record book, minutes of my meetings, showing that I've renewed my corporate status, that I have, you know, filed articles and bylaws and things like that. And if it looks like all I did was set it up and then forget about it, maybe I'm commingling funds from my bank account, whatever else, the court can say, you know what, you didn't follow the rules that society set up in order to give you this advantage of limited liability, therefore bring out your own checkbook. That's what piercing the corporate veil is. Yeah.
How easy is that to do?
It's easier with a corporation because the list of formalities is longer, so it's a longer to-do list. With a limited liability company, it's a shorter to-do list, so it's kind of easier to keep up with it and show that you've kept up with it. And I think when you have just a single person that's behind the corporation, I think it's pretty easy to do because they get sloppy and they don't really keep their records, and it's kind of awkward to have an annual meeting with yourself and write it down, right? And so people don't do it, and it's easier to pierce. If there's more people and you're actually having meetings and you've got notes of the meetings, it's tough. It's tough. The court wants to support that. There's a reason that that's there. So the court wants to support it, but if you don't do your part, they won't.
So if you've done all, dotted all your i's and crossed all your t's, and yet you have set it up to defraud people, will the courts pierce for that?
If the court can find evidence that it's really a sham business, even though you've got all your paperwork, and they feel, and it's really going to go to a jury of peers, and if the jury says, gosh, yeah, but that just this person is so sympathetic, here they are injured and they need hospital bills, and this person clearly has the money, and we're not sure what that corporation does. Yeah, I mean, you can sway a jury by sympathy and by feeling that something's not right about the situation. So, you might ask for a jury trial instead of a judge trial. A judge trial is more like looking for dotted i's and crossed t's, but you can request a jury if you think your client is really sympathetic. Okay, any other questions about that? We know what the corporate formalities are. What's an S election? How do you get from a C corporation to an S corporation? If you file for corporate status, you're just automatically a C, unless you choose S. And an S election is a form you fill out with the IRS saying, I'm choosing to be an S, I'm choosing to be taxed as a partnership, or I'm choosing flow-through taxation. When you make that S election with the IRS, you become an S corporation. Otherwise, it's the same. The S really only has to do with who your shareholders can be for tax purposes and your tax process.
So what's the benefit of being taxed as a partnership?
Great question. I'm so glad you asked. So flip your paper back over, and you'll see in the middle of C corporation, it says double taxation. In the middle of S corporation, it says flow-through taxation. Only taxed on profit or loss as personal income. So here's how it happens. Because the corporation is a legal entity, separate legal entity, legal person, they're taxed. So the corporation makes a profit. See if I can remember how to do this. So the corporation makes a profit and they pay tax, right? And then the remainder of the profit goes where usually? Why do you set up a corporate? Why do you go into business? Give them more money. So the shareholders get a dividend, and when they get the dividend, they pay tax, right? So there's a double taxation. First, the corporation is taxed on the profits, so the shareholders don't get a piece of that because it goes to tax. Then the rest, the balance, goes to them and they get taxed again. Okay? With an S corporation, what happens is you get the profit, and let's say you've got 5 shareholders, and you just take that profit. You've got $100,000 and 5 shareholders, you each get 20, and you pay tax on that. That's it. So the full amount of the profit comes to the shareholders by dividing their percentage, and then they pay on that amount. So it's just taxed once, not twice.
So is the only reason why you want to be a C Corp instead of an S Corp is if you're interested in getting like VC investors and potentially going public in the future? Or?
Yeah, yeah. The advantage of a C corporation is that you can have anybody invest in you, so including other corporations or other limited liability companies. So investors have to invest in a C Corp. They just don't write a personal check for investment as an individual. They invest as a company. But with the S Corp here, let me just finish this up first. But let's say the company took a loss, and it was a $100,000 loss. What's the benefit? You don't have to pay taxes, right? But if you had other income, you could take that $20,000 loss, offset it against what income you have, subtract it out, and be like, oh, now I only owe $5 in taxes because I had a business that was operating at a loss. So early, this also includes LLCs. So early in a business's startup where you're operating at a loss, it's great to get this flow through taxation because then you can take those losses against other income you have. Then once you become profitable, you're still saving over here because you're only being taxed on the profit once and not at 2 levels. So there's some advantages. Over here, you can, if you've got a profit, you can push it forward and defer your taxes, but you can't write off a loss. So
You may have already done this, but could you give us like a standard example of what kind of company would set up in this story?
yeah, it's usually closely held like a family company where it's all individuals. And the reason, one of the incentives of an S corporation is the way, if you're paying yourself a small salary, has to do with the way you're taxed on your salary within an S corporation. But they're usually family-owned businesses with a lot of family members that are that each have shares and no corporation.
It's kind of a way to split up equity.
What's that?
Just helps to split up equity.
Yeah. And it's got that tax advantage. Okay, any other questions on that? Yeah.
Can you, once you've already filed to become a corporation, can you switch from a C to an S? C or once you scale, or you kind of
The problem with switching from a C to an S is you probably went for a C in the first place so that you could have something other than individuals be shareholders.
Right.
And so now you've got to somehow get rid of all them and turn them into individuals. So that's the problem going that way. Going this way happens quite more frequently. It's a little family business, it's an S, it flows through, it's easy. Now you want to go public. All you're doing is opening up the opportunity for foreign investors and corporations or LLCs who are investors.
So on the sheet it says that if not elected within 6 months, then you become a C, but can you ever go back to an S?
Yeah, I think there are, the IRS says you have a 6-month limit to elect an S. I at one time had a situation where it went beyond that and we thought we had filed it, we hadn't, and there was a way to appeal to the IRS and get an extension on that and become an S. But I don't know how squishy that, I don't know how rigid or squishy that is. I think you kind of have to reform your corporation at some point.
So I'm familiar with the small business that runs under the LLC, and the main owner pays himself as an employee and then does a consulting fee with the profits.
Mm-hmm.
So does that just mean he's only liable for personal income?
Yeah, I'm not sure the whole picture of that strategy, but if you're also taking a salary from the business, well, I don't want to put that under loss. Maybe you've got a salary as well. That you're also paying, income tax, plus you're paying your profit. So that's your total tax. But you may have a reason why the reality is you don't wait till December 31st and give yourself a check for $20,000, right? You got to get money out of the business along the way. And so a consulting fee is one of the ways you would do that, is you consult on management issues and the company pays you something. But then that becomes other income, and at the end of the day, if you have profit, you add them together. I'm not a tax person, so you got to keep tax questions basic. But that one I can answer. Okay. DBA, I'll just say really briefly about DBA. The reason I associate it with sole proprietorship or partnership is because you're not already filing anything. So if you want to have a special name, you have to file something to get the special name with the state, and that's called a DBA. On this side, where you're already filing something, guess what? The DBA is just built into that process. So I don't call it out, but essentially it's rolled into the process of filing your articles. Part of your articles is, what are you going to name your corporation? Called DBA, there you go. But you can't file a DBA over here if you've been doing business for a while under one name and now your business is shifting and it's time to go from whatever it was to Vivint. What was it before Vivint? Apex. You were Apex, now you want to be Vivint. You don't want to reform your whole corporation, you're just changing the name. You can file a DBA then and go change your name with the state. The DBA is just, it stands for doing business as, and it tells the state how to match up a name they're seeing out in commerce with who's responsible to pay the taxes. That's all it is, okay? So anybody can file a DBA, but over here, if you want a special name, you have to file a DBA because it's not already part of the process. Oh, joint and several liability. Where does that come up and why is it a problem? Partnerships. It comes up in partnerships, and why is it bad? You've already got unlimited personal liability. How much worse can it get?
Okay, if someone sues you, they can like split partnership and just attack one person?
Yeah. You are responsible for the actions of your partners and their liability. And so you're jointly liable, but also if someone sues the partnership and they say, oh, you know, a couple of them are just college students, they don't have anything, but then this one guy has a lot of money, we'll just go after him for the whole thing. And then he can sort it out with his partners later. So joint and several liability means you could share the liability jointly with all your partners, or somebody could just focus on you for the whole thing and then make you sort it out later with your partners. So it's worse than personal liability because you don't always control what your partners do in the business. The dumb knuckleheaded things that they do, and then you're responsible financially, right? Okay. Last thing, yeah.
So does this just like fall upon your partnership or your partnership business by default?
Yep.
Okay, so to get around that, you have to not be a partnership.
If you don't want joint and several liability, and there's more than one of you, you have the option to form a corporation or a limited liability company to shield everybody from liability, and then you don't have to worry about it unless what happens? When might it come back to bite you even after you went and set it all up right? You don't follow through on the formalities and they pierce the corporate veil, and then you're back in the joint and several liability bucket as a partnership. Because once the veil is pierced, you either fall back to a sole proprietor or partner.
So the limited liability company is a company, it's not a corporation.
Yeah, it's a company. I mean, it's covered by the corporate code, and it's listed, I mean, it's a word that's used interchangeably, but very technically, there's corporations and limited liability companies.
So the example you use about the t-shirt stand selling Disney t-shirts that got sued, had they been an LLC, they could have just walked away from the business and not have paid that $10,000.
It's a good point, right. Disney could have ended up with a stack of contraband t-shirts.
Okay.
But if there was no other money in the corporation, you just close the corporation and walk away. And Disney's going to say, no, you know, we're going to pierce your corporate veil, and if you've set it up right and you've maintained it, all Disney can get is a stack of t-shirts. Yeah, great, perfect example. If they did pierce the corporate veil, though, and there was two of you behind there, they could pick which one had the most money and just go after that person. That would be the joint second. Okay. I'm tired. It's a lot, isn't it? Okay, the last thing I want to point out to you is the capital accounts. Just make sure you understand this flexibility within an LLC. That you might start out with a certain voting percentage or a certain ownership percentage or a certain equity payout percentage. But a capital account allows you to adjust people's participation over time financially. It's just a little accounting function. You can do it every quarter, you can do it every week. every year, whatever you want to do, and you look at what people have put in and what you're going to value. So it might just be money-based, and people put in money, you mark it down. People take out money, you mark it down. Maybe they put in time, and you put a value to that. Maybe they do something creative, and you put a value to that. And you adjust those accounts, and they fluctuate. And you can tie different things to those accounts. You can say we're all going to have a 25% voting right. We're all going to have equal, there's 4 of us, we're all going to have equal voting rights. But if the company is liquidated, we're going to look at the capital accounts and pay out according to the percentage of ownership in the capital accounts. Or you might say, well, if I put more in, I should have a bigger vote. So you might tie the vote, your weight of your vote to your capital account. You can choose how you do that, and that's what makes limited liability companies so flexible. Is, what you claim as your ownership percentage can be different than how you vote, can be different than how you pay out. And it just depends on what you choose to tie to the capital accounts and how you choose to value the capital accounts. Yeah.
Who writes the rules for the capital accounts?
It's in the operating agreement. And it's when you form the corporation, when you form the limited liability company, you decide all of that detail. And if you're doing it a certain way and you decide it needs to change, then you can vote a change into your operating agreement if enough people. Okay. No more on this, I think, right? The green sheet or the white sheet, same sheet. I feel like we've just been over this, and it should be really fresh in your mind. So here are big takeaways. Pay attention to what protects the idea and what doesn't. Between copyrights and patents, that's really key. Remember that at trademarks you have 2 ways to get rights. Copyrights you have 2 ways to get rights. But patents and trade secrets, they kind of cover the same thing but work differently, but they overlap. If you're trying to get patent rights, you still treat something as a trade secret. You still always treat something as a trade secret. So with patent, in order to get patent rights, is it novel, useful, and non-obvious? Novel meaning new, that there's nothing in the prior art that this has been disclosed before. So by disclosing something, you can lose your patent rights. So treating it as a trade secret under non-disclosure protects those patent rights. Do you see how those work together? Think of it like this. We said you might have a big idea, and you go to the patent office and you say, I'd like a monopoly on that idea, but monopolies are very scarcely handed out, so the patent examiner only wants to give you this big of a monopoly, right? They're rare, they're precious. But your idea is here, and you're eventually going to get this. That margin you want to keep as a trade secret. Okay, it might be that someone else somewhere in the world knows something about it, but they don't know how it relates to your business, how it relates to your product mix or your pricing mix or something else. So that margin you want to keep as a trade secret. So if you're submitting the whole thing as a patent and you're waiting 3 years to know how much you're going to get, what do you do with that? With all of it? How do you treat it? Trade secret. And that means, what do we use when we're discussing it? A non-disclosure agreement. Because as long as you can talk about it, as long as it's protected by the agreement, it's not considered public and it's not considered disclosed publicly. Have I made sense in tying those two together for you? And then we've still got that weird issue about if you disclose it before you protect it, and you make a public disclosure at a conference talking about your research, and then you're like, oh no, I disclosed and I forgot to do something. Can you still get patent rights? If you don't do a provisional patent, can you still get patent rights? Somebody said yes. Where can you get those? And for how long?
In the U.S. for a year.
In the U.S. for 1 year. We still have that grace period in the U.S. If you're only concerned about U.S. patent rights, you have 1 year after disclosure to button it up and send it in, and you have U.S. rights. But what have you lost?
Trade secret.
International rights and possibly your trade secret. You've lost your ability to patent internationally. As soon as that comes out of your mouth, you've shot yourself in the foot. You've created your own prior art. It's public now, and the examiner will say, no, that's already known. Too bad you were the one that made it known, but it's an absolute bar to patentability. So there's a difference. US, you still have that 1 year grace period. Internationally, you've lost your rights. And so US squared that up by coming up with a provisional patent, right? That lets you just slap a cover sheet on your sloppy notes as long as there's enough there to teach the invention. And then you have a year to put it in a formal patent, and the rest of the world considers it that it was filed at that provisional. The big takeaways from patent, besides that novel, useful, non-obvious, and the fact that it protects the idea and how long it lasts. The reason, why did we make the changes we've made in the last few years? Why did we make the changes to patent law we've made in the last few years?
Just kind of standardize it with the rest of the world.
Standardize it with the rest of the world so that we can become part of the Patent Cooperation Treaty. So to come in line with the rest of the world, to join the Patent Cooperation Treaty, there are three main things that we changed, and they're not on your green sheet, so you'll want to write them down. Three main things that we changed. First to invent became first inventor to file. The rest of the world is just plain first to file. But we wanted to be clear that you had to be both an inventor, that you got the invention, not just stole it from somebody else, and that you were the first to file. So first inventor to file. We came up with that provisional patent to bridge the gap between giving a 1 year grace period where the rest of the world doesn't. So the provisional patent was a change. And the last one was that change from 17 years after it issued, which allowed US inventors to just drag it on forever, and nobody knew for sure when the patent was done, and then get 17 years. And came into line with the rest of the world, so everyone knows the date certain. You file it, you get 20 years. That's it. Same with everywhere in the world. File it, you get 20 years. It can take you forever to prosecute it, in which case you get the last 10 minutes, or you can work with the examiner, get it issued quickly, and then you get as much of the 20 years as is left. I wouldn't worry too much about what's in the licensing category, except just make sure we talked about first sale doctrine as part of the copyright category, so make sure you understand that. What that is. First sale doctrine says that if you sell something and the title passes, the person who bought it can do with what they want. So if I buy a famous painting, the Mona Lisa, and I buy it and I take it home, I can draw a mustache on it if I want. You know, I own it now, and I can do with it what I want. When you license something, remember it's a permission to use, and that means I can only make the changes that the copyright owner permits. And so for things like software, if I'm going to put my software out there, but I don't want people making derivative works and using my software and reverse engineering and doing other things, I can license only the right to use exactly as it is, but I can reserve all the other rights. Or if I want to do open source software, I can put whatever rules I want, and then you have to follow those rules. But if I sold it, once it's sold, that new person can do with whatever they want. So if I acquire a company and I buy their technology and I want to repurpose it for something else, I can do that. Because it's first sale, title has passed, new owner can do with it what they want. If you want to avoid somebody getting your stuff and doing with it what they want, you license rather than sell. Okay, we've got 6 minutes. I had a lot of questions at the end of last class about the trademark search assignment. It's due tonight. Hopefully you have begun your search so you know kind of what kind of obstacles you're running into. The biggest problem I think I'm having is people who have a made-up word, and so when they put it in, they're getting no hits, and then they don't know what to talk about. So break that word into its logical, if you're Nutri-Grain, then search nutrition and grain, or nutrient grain or something. Break it down, find the closest English words to what's in your made-up word. If it's truly a made-up word, look at some variations on it. You can look at the industry. An example that I gave one of my students was let's say you're In-N-Out Burger and you put in In-N-Out and you don't get anything, no hits, right? It's a totally unique name. Can't think of anything to talk about. Here's a possibility. You can say, looks like it's a totally unique name. I don't think anyone's going to be confused by it. So I went and looked at the industry and I found out there's a McDonald's, a Carl's Jr., and a Burger King, and an In-N-Out Burger. And hey, you know what? McDonald's and Carl's are both based on people's names, and they sound totally different. Burger King has a descriptive word and some reference to their freaky mascot. So I don't think that and In-N-Out has like a quick serve kind of connotation. So I think that the commercial impression of all of those are so unique that I really have a distinct trademark in my industry. That's a fine way to approach it. Make sure that you are attaching your screenshot of your search results, even if it says test no results shown. You can search synonyms or common misspellings if you want to try that for some stuff to talk about. Make sure you attach the first page of your Google search results. Make sure you talk about what you found at the different domain names. I had a student last class who had a crazy spelling, but all the domain names were available, and he says the one problem I had was when I went to the regular spelling domain name, it was for a condom company in Australia. Well, how do you feel about your customers, not knowing you have a weird spelling and finding that? You might want to talk about that. So I hope that in the process you don't come across any websites that are